So the headlines, and maybe this is sort of how you get people to click your story, make it sound like there's lots of unknowns, and these aren't even sort of the worst of it, but a lot of we should be worried, right? That there's something we don't know, and we don't know the ramifications, and somehow this is going to upset our economic development in Canada. That's sort of what I was taking away from reading a range of news articles this morning. So I want to try to respond to what I see as being a lot of fear-mongering happening from mostly conservative camps. I also want to provide some information on what the status of the UN Declaration and Free, Fair, and Informed Consent is in international law. And I will try to answer some of these questions as well as we go through it, as we start thinking about what are the next steps, or where do we go with moving forward on Indigenous rights in Canada. So the other question I have, has anyone been in this room and heard me do a similar presentation before? The thesis all okay, excellent. So where I like to start is trying to understand, why is there even a declaration coming out of the UN that looks specifically at the rights of Indigenous peoples? And the best way, I think, to answer that question is to read the preamble of the UN Declaration. So on the screen right now are 4 preambular paragraphs. Those are the opening words to the UN Declaration that provide some context for the declaration and guide our interpretation of the actual articles or the rights that are contained in it. And so I don't know if people can read throughout the room. I have a lot of text up there. I tried to keep it at a readable size, but it basically, when we think about why is there a UN declaration, the UN starts by recognizing that Indigenous peoples are in fact peoples. Hopefully not a groundbreaking statement, but a really important statement to make, because there's many instances in Canadian law that have treated Indigenous peoples as not peoples. We have 1880s US court decisions that continue to influence Canadian law today that talk about Indigenous peoples as savages whose occupation is war, right? And this was some of the early justification for taking away Indigenous peoples' lands and removing them from their lands. So our starting point is recognizing that Indigenous peoples are in fact peoples, and that they are equal to all other peoples of the world, meaning they are entitled to the same fundamental human rights that all peoples of the world are entitled to. However, we have to also recognize that they're Indigenous peoples, and so they bring some differences. And we should be celebrating those differences and not using those differences as a reason to take away Indigenous peoples' rights. The UN then goes on to say that they're concerned that Indigenous peoples have suffered historic injustices as a result of colonization and the dispossession from their lands, territories, and resources. Again, hopefully not the most groundbreaking statement, but a really important statement to make. Some of you may recall a moment when our former Prime Minister tried to say that, and tried to deny sort of Canada's colonial history, right? So this preambular paragraph recognizes that colonization occurred in countries like Canada, and importantly, that it was a negative experience. And it particularly highlights one of the key negative aspects of colonization is the removal of Indigenous peoples from their lands. And the impact of the removal of Indigenous peoples from their lands means that it prevents Indigenous peoples from exercising the right to development in accordance with their own needs and interests. Then, and I think this is really critical in today's time, the UN says it is convinced that recognizing the rights of Indigenous peoples will actually enhance harmonious and cooperative relations between Indigenous peoples and the state. And I think that directly speaks to some of the fear-mongering that we're seeing in the media today. Somehow these journalists and commentators are trying to say that the assertion of Indigenous peoples' rights is tearing apart Canada, or that it's going to lead to some sort of strife or uncertainty. And so blaming Indigenous peoples for the current state of discord in the country and the uncertainty we have. the UN is really clear. It's saying where we fail to recognize the rights of Indigenous peoples, we continue to negatively impact fundamental human rights. And so we have to recognize that in states where we fail to recognize the rights of Indigenous peoples, we're currently broken. And if we want to fix things, or we want to reconcile, as we talk about in Canada, the way to do this is actually recognizing and implementing the rights of Indigenous peoples. I can't underscore this enough. And so we have to start accepting that we're broken in Canada. That the failure to recognize and protect Indigenous peoples' rights is leading to our status quo today. And so by engaging and implementing Indigenous peoples' rights, we reset the relationship between Indigenous peoples from a colonial relationship to one that is based on principles of justice, democracy, respect for human rights, non-discrimination, and good faith. Right? And I think that's the challenge that we experience, is we have to start recognizing that right now the current economic development system benefits certain segments of Canadian society while negatively impacting, to say the least, another segment of Canadian society. So if we want to move forward, we recognize rights, and that's going to reset the relationship. And now human rights, justice, democracy, and non-discrimination will be the basis for the relationship. And so the UN solemnly proclaims the UN Declaration as a standard of achievement to be pursued in the spirit of partnership and mutual respect. So here, again, just a reminder that implementing the rights of Indigenous peoples is not something that the Canadian government can do on their own, but rather they need to work with Indigenous peoples. And that the implementation process needs to be done in the spirit of partnership and mutual respect. And I think part of mutual respect is an acknowledgement that the Canadian government does not always know better. So I think this is a really powerful story, and I'm hoping that it's starting to sort of give you some understanding of the concerns that I see when I start reading the news today. I think it's also important to understand that the UN Declaration is not the only and not the first international human rights instrument that protects Indigenous peoples' rights. On the screen is a whole host of other international human rights instruments that Canada has signed that also should be protecting the rights of Indigenous peoples. So starting in the 1960s, we have the Convention on the Elimination of All Forms of Racial Discrimination. We have the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, and the Convention on the Elimination of All Forms of Discrimination Against Women, and the Convention on the Rights of the Child. All of those instruments are general human rights instruments that apply to everyone in Canada, and that should include Indigenous peoples. The benefit or the goal of having the UN Declaration is to ensure that we understand how these general human rights apply in the specific Indigenous peoples context. So what the right to culture looks like for me as a Métis woman in Manitoba might look different than the right to culture to any of our other communities in Canada. Right? So we have these general international human rights instruments that Canada has signed that are also meant to protect Indigenous peoples' rights. And the UN Declaration gives us a lens to understand these general instruments. I added back in this slide today because one of these international human rights instruments has made the news this month. Does anyone? So in the last, I think it was last week, the UN Committee on the Elimination of Racial Discrimination issued a decision that was calling for Canada to step down in a few of the key development projects in British Columbia. Told the RCMP you need to stand down, that Canada is failing to uphold the rights of Indigenous peoples. And there's been all sorts of pushback to that specific decision, but I just wanted to highlight that if you read any of those articles, they're not actually talking about the UN Declaration specifically. the one author tried to say, look, Canada supported the UN Declaration and now we have the UN chiming in on our domestic affairs. But it's not really accurate. Canada signed onto this convention on the elimination of racial discrimination in the late 60s or maybe the 1970s. So that process by which Indigenous peoples can assert their rights was something Canada decided to do in the 1970s. The only benefit we have now is that additional lens of the UN Declaration to understand, again, how eliminating racial discrimination might have particular aspects to be addressed in the Indigenous peoples context. Also, this last one, the American Declaration on the Rights of Indigenous Peoples, I included that one because the UN is not the only international human rights body that has a declaration on the rights of Indigenous peoples. There's also the American Declaration on the Rights of Indigenous Peoples that applies to Indigenous peoples in the Americas. And I actually mean the Americas, not Canada, US. I mean from Canada all the way down to Chile, Argentina, South America, Central America. And I only highlight that because there's some really interesting provisions on treaties. I don't know if I'll get a lot of time to talk about it today. But the American Declaration on the Rights of Indigenous Peoples talks about the obligation of states to implement the spirit and intent of treaties and uses that specific language, which is a little bit different than the UN Declaration. So when I started talking about the UN Declaration, and Canada, people didn't really care. This was sort of the 2010, 2011. A lot of people wouldn't open the doors, or they sort of was like, oh, interesting, but not relevant. Things really began picking up in Canada, I think, with the Truth and Reconciliation Commission's final report. And the the Truth and Reconciliation Commission referring to the UN Declaration as a framework for reconciliation. I'm hoping that with my introduction and my version of why we have the UN Declaration, it helps you understand why the Truth and Reconciliation Commission was referring to the UN Declaration as a framework for reconciliation because of the way in which it resets that relationship, right? Protecting Indigenous people's rights and moving us away from that colonial relationship. So the TRC calls to action include calling on various actors to know more about the UN Declaration and to start taking action. And so we're seeing an uptake in Canada and having a bit of an easier time moving forward on a few things. So just a little bit more background on the UN Declaration before I start getting into some of the more specific provisions. The UN Declaration is a resolution of the General Assembly. I only highlight this not because I'm a lawyer and I think the law is fascinating and that everyone should learn the law, but because it's important to understand the UN Declaration in Canada to know what it is. So the UN Declaration is not the same as those international human rights treaties that I was referring to. The resolution was passed by the General Assembly. There was no opportunity for Canada to sign on to the declaration the way you would sign on to a treaty. So the treaty Canada physically has to sign on and agree to. The resolution is a statement by the General Assembly, and Canada's only opportunity to influence its status in international law or to indicate its position was by voting at the General Assembly. Similar to when an MLA or an MP votes against legislation in the legislature or parliament, if the bill passes, it becomes part of law, and regardless of your vote, you're obligated to follow it. It's the same with the UN Declaration. So even though Canada voted against the UN Declaration, that had no impact on the relevance of the instrument in Canada. It passed by a majority vote at the General Assembly. The UN Declaration was part of international law and thus had relevance and application in Canada. When Canada voted against it, trying to assert the Declaration in Canada was very hard. Trying to get Canada to take steps to implement or engage in the national action planning process was very difficult because there was a lack of political will. But the Declaration still had application. And so when Canada starts taking these steps to say they're now endorsing and supporting the UN Declaration, it's really showing the political position of the government, and in theory making it easier for those of us advocating for its implementation to be a bit easier. One of the reasons that I'm so passionate about the UN Declaration is because the way in which the rights that are recognized in the UN Declaration not only reflect general international human rights standards, but it takes those general international human rights and talks about them and grounds them in Indigenous people's own laws. And so when you're talking about Indigenous people's rights to their lands, territories, and resources, I can sort of talk about the general state of international human rights law, but implementing those rights requires us to refer to people's own laws. So how did the Anishinaabe of this area use the land? What were the laws that governed who could have access when and where? What territories did they assert jurisdiction over, etc. So it's a really powerful way to see how Indigenous law and international human rights law can work together. And importantly, I think implementing those rights in Canada requires us to fold in and bring in Canadian law. And so in some of my work, we've talked about implementation requires writing together international human rights law, Indigenous law, and Canadian law. And we use the metaphor because of the way in which braiding works, that you have 3 strands, and in order for the braid to work, all strands have to be equal weighted. For those of you who've ever tried to braid hair and have ended up with different size pieces, the braid looks really wonky, right? And it doesn't work, and it sort of skews all over the place. But when you have 3 equal pieces that are working together, you end up with a stronger piece, right? So this idea of braiding also means that by working to implement the UN Declaration and bringing together Indigenous law, international human rights law, and Canadian law, we actually strengthen all 3 legal systems. Maybe I'll highlight the last point before I move on. The UN Declaration does not define Indigenous peoples. It's an interesting tidbit for people. Any ideas on why the UN Declaration might not have a definition of who is Indigenous? One of the reasons I think is it's different. We want to allow the definition to evolve. But I think for me, in some ways, maybe even more importantly, is the idea that if the UN defined who is Indigenous, we end up in that same colonial catch-22 that we're trying to get out of, right? So it's really important that the UN and the member states not be the ones defining who is Indigenous. That doesn't mean that there's no understanding of who is Indigenous. This is something that the UN studied, I would say, for at least 15 years before the UN Declaration went on. So there's lots of very generalized understanding of who is Indigenous that has come through over the years. But it was important for the UN Declaration to not, in fact, say, you are Indigenous, you are not, and sort of either in reality or in appearance look like you're handing over that power to the states, right? So when we talk about self-determination, it's really important that Indigenous peoples maintain the recognized right to define their own membership and determine for themselves who is Indigenous and who's a member of the community. So the UN Declaration is really broad. It covers a whole range of areas, from equality, non-discrimination, and self-determination to life and security, rights against genocide, or right to be part of their community, a whole bunch of cultural, religious rights, some education, media, and employment rights. A really interesting provision that I won't be able to talk about today is the provision that talks about the right of Indigenous peoples to have their aspirations accurately portrayed in public information. So for those of you who might be educators or work in government institutions, think about all the publicly available information that you've ever come across on Indigenous peoples and ask yourself whether that information accurately portrays Indigenous peoples' aspirations. Right, so a really interesting call for a review of curriculum. But I would also say it requires statements of governments to accurately portray the aspirations of Indigenous peoples when they're talking about Indigenous peoples. So I think it's really important when, say, the BC government is making statements about some of the conflicts that are arising around pipelines, it's important that the government accurately reflect what is actually being asserted by the Indigenous peoples. Lands, territories, and resources, self-government. But what I want to talk about today after I talk about Canada's position is I'll really briefly talk about lands, territories, and resources. I'm going to focus most of the talk, probably like 3 minutes I have left, on the right to participate in decision-making and free-party from consent. Because that is in the media, I feel like, every day, multiple times a day. And I think there's so much misconception out there that's really problematic. So I'm going to take this opportunity to try to clarify a few things. But Canada's position now stems back, I think, best to 2016, and at a UN meeting, we had both the Minister of Justice and the Minister of Indigenous Affairs indicating Canada's what they called an unqualified support for Indigenous peoples. Wow. What they're talking about is that Canada is now a full supporter of the Declaration without qualification. And that statement is really important, and I take Canada at their word. What is really unfortunate, and I was at the UN here and I was speaking to Canada after they made this statement, is that right after they say this, they go on to say we intend nothing less than to adopt and implement the UN Declaration in accordance with the Canadian Constitution. So I have spent a fair bit of time thinking about that little phrase, and I think importantly, because I work a lot in international human rights, I have a fairly good understanding of how international human rights and the Canadian Constitution work together. And I'm pretty sure that whoever threw in this statement meant to say that when implementing the UN Declaration in Canada, we are bound by the division of powers set out in the Constitution. Now, for those of you who aren't constitutional lawyers are probably saying, what does that mean? That still means nothing. What that means is under the Canadian Constitution, there's a list of federal government powers, area that the federal government has exclusive jurisdiction over, and there's an area of the Constitution that lists the exclusive powers of the provincial government. Did you know this? I did not know this. So if we think about what is the federal government responsible for, banking, money, postal service, Section 9120, wow, I'm forgetting. Jurisdiction over Indians and lands reserved for Indians. What else falls to the federal government? Oceans. What are the things that the province is responsible for? Does anyone know? What areas does the provincial government legislate? Anyone know these things?
Property and civil rights.
Property and civil rights. Natural resources. Education. Healthcare, social services. So if you think back to that list, or I can help you out, what we could do is look at this area and say, under our Constitution, what areas does the federal government have jurisdiction or the ability to implement, and what areas do we need the provinces to engage with in order to implement? So I think what the statement says, or what it has to mean, if the first statement about unqualified is accurate, it means that in order to implement the UN Declaration, we may need the provinces to be involved, particularly when we're talking about implementing areas in relation to lands and natural resources. Because most lands in the provinces under the Canadian Constitution are recognized as provincial lands. Most of those minerals, the forestry, the mining, that's all provincial regulation and legislation. So we need the provinces on board. When you read the next sentence, by adopting and implementing the UN Declaration, we are breathing life into Section 35 and recognizing it as a full box of rights for Indigenous peoples. I think it also helps us understand what that previous sentence means. I don't think the government meant to say that the only way to implement the UN Declaration is through Section 35. Right? I don't think it meant to be a limiting statement. What the government is saying, I think, is that full supporting, we're going to need the provinces on board, and since we already recognize and affirm the existing Aboriginal and treaty rights of the Aboriginal people of Canada in our Constitution, which is the highest law of the land, we have one method to start thinking about implementing the rights. However, caveat, the courts have taken a really narrow approach to interpreting Section 35 rights. And so now if we use the UN Declaration, we have one potential way to expand what is being recognized and affirmed under the Canadian Constitution. So Canada has made this big, bold statement, including supporting the free, prior, and informed consent. We didn't see a lot of movement, but what we did eventually get is an announcement that there was going to be a working group of ministers that review laws and policies, either by design or governmental process. Very little is known publicly about this review. I don't know if it happened. Maybe it's a cabinet process and it's just not, subject to public information. But that was announced. We had Bill C-262 that was attempted to be drafted to implement. Some people say it's died. I feel like it was killed by a couple of conservative senators. But regardless, it did not succeed in making it into law. But we do have the Canadian government reiterating its promise to pass legislation to implement the UN Declaration. And so this is, from what I understand, top of the federal government's agenda, and I actually believe there's ministers and staff working on this already. So I do think that we will see something coming out. What it will look like, we don't know. What a lot of us are advocating is that it has to be at least the level of what Bill C-262 got or better, right? So that should be the starting position, and we can work up from there. I throw in Manitoba's position, because it's worth thinking about if we need provincial involvement, what is Manitoba's position? In that Reconciliation Act that passed in, I don't even know the year, was that 2016? I'm going to make up. I can't remember. Under the former government, we had the legislation on reconciliation, and it includes some reference to the UN Declaration. From everything that I can tell, the current government is silent on the UN Declaration. Maybe that's useful. Maybe saying nothing is better than speaking out against it. I don't know, but we don't really know what's happening in Manitoba right now. Now to talk about a few rights, and as I said, I'm going to fly through this and try to focus on free, prior, and informed consent. And I will try to talk about the treaties because we are at the treaty relations. So the rights to lands, territories, and resources are really broad. It includes the rights to lands, territories, and resources. Do we know the difference between those three? So land tends to be a bit more the physical. Territory is that broader area, so not lands that someone's sort of residing on, but what can be referred to as traditional territory. Sometimes we hear that word. So I think in Canada, when we hear territories, we should be thinking either traditional territories or potentially, I think, could also include treaty territories. And natural resources, so the actual resources, which isn't just minerals, it can also include potentially the flora and fauna, right? Indigenous people's use of resources is broader than just sort of mining and forestry. And it includes the right to own, use, develop, control, and strengthen the relationship with, right? So even where Indigenous peoples may not be residing in their territory or may not be the only ones there anymore, Indigenous peoples have a right to strengthen their relationship with the lands. And there's lots of studies done at the UN that recognizes the special relationship that Indigenous peoples have to their lands, recognizing that Indigenous peoples gain their identity through that connection to the lands, and don't view lands as merely a commodity to be exploited. So that protection, that guardian relationship that many Indigenous peoples have towards the land is a relationship that is recognized under international human rights law. It applies to lands that Indigenous peoples currently live on, as well as lands that they have traditionally used or otherwise acquired. And I think this is important in a place like Manitoba because we have several communities that have been relocated, right? And so the UN Declaration is really careful to ensure that communities that have been relocated and may not be living within their traditional territories, they haven't lost all of their rights, that you continue to have rights. It also allows for recognition, I think, of lands that Indigenous peoples have recognized control under Canadian law through things like the treaty, land entitlements, or purchases that are settling some of the TLEs. So under the UN Declaration, Canada is obligated to work with Indigenous peoples to set up a process that identifies and protects these lands under Canadian law. Okay, and I think this is one of the key things we need in Canada. The land question is really unsettled. And so Canada is supposed to be setting up a process to identify and protect Indigenous peoples' lands under Canadian law. And I just want to say that in Manitoba, it's not a foregone conclusion that Indigenous peoples gave up their land rights under a treaty. That interpretation will not succeed anywhere in international law. The land question is clearly still open up in Canada and needs to be, in Manitoba and needs to be resolved. And leading into the next set of slides, the government must consult Indigenous peoples before allowing any activity on Indigenous peoples' lands, territories, and resources. That idea is encapsulated in the right to participate in decision making. And I want to highlight this because lots of the media talk about FPIC, right? Free, prior, and informed consent, and they're all worried about consent. And is it a veto? And now the government can't run, and we're never going to have development again, and Canadian economy is going to crash, and you hear all these horrible things. What is actually happening in the UN Declaration is a recognition that any time the Canadian government, or a Canadian government, including provinces, make a decision that impacts Indigenous peoples' lands, Indigenous peoples have a right to be part of that decision-making process. Indigenous peoples must be there in a real way, making decisions that impact their lands. That sounds a lot less scary, doesn't it? That's not what we hear in the media. To guide us in this process of what is the standard and how do we engage Indigenous peoples in that decision-making process, we have the idea of free, prior, and informed consent. So, very few people debate free this idea that Indigenous peoples' participation in decision-making processes should be without coercion. Unfortunately, I think we still continue to see a lot of divide and conquer tactics used. We hear all sorts of statements by the previous Liberal government in Ontario about the Ring of Fire development, that we will work with those communities who are willing to work with us. Forget about those of you who are resisting. Right, so we do see that divide and conquer tactic, unfortunately, being used. Or in the Wet'suwet'en case, the Band Council agreed, so we have our consent. It's just the hereditary chiefs that are holding out, right? So we've got the consent of these groups, so we're going ahead. Which in some cases ends up pitting Indigenous peoples against themselves, which is a really terrible approach. And sort of reiterates and perpetuates a lot of the damage that colonization did to many of our communities. Prior is the timing, so ahead of time. Informed means with enough information to understand the implication of the decision being made. Consent. This is where things get interesting or potentially complicated. So, consent in international human rights law is quite readily understood. There is a report, I can hold it up. You won't be able to read it because I can't even read it because I printed it way too small even for my own eyes. But coming out of the United Nations Expert Mechanism on the Rights to Indigenous Peoples, they concluded a study on free, prior, and informed consent, a human rights-based approach in 2018 that reiterated the fact that this idea of free, prior, and informed consent first started with those international human rights treaties in the 90s and has continued to be applied and refined and clarified over the last 20 years. Consent means that Indigenous peoples have agreed to the proposal. Therefore, any process that is engaged should be aimed at reaching an agreement, right? So Indigenous peoples are involved in the decision-making process, and you sit down at the table intending to reach an agreement with them. To fulfill the consent requirement, government should not be approaching Indigenous peoples with an expectation to say yes to a predetermined question. You have to start more open, right? You're involving them in the broader process. It is important to note that Indigenous peoples have a right to say no or withhold consent if they determine that the proposal is not in their best interests. When consent is given, it should be consistent with Indigenous peoples' own custom laws and protocols. Right? So consent means consent. Let's not start trying to think Indigenous peoples have a different level of consent than you have in any other context, right? Consent is also the foundation of Canadian democracy. Let's not lose track of that people in Canada engage in consent processes all the time. This is what democracy is. So it extends to Indigenous peoples, and where Indigenous peoples' rights are specifically and especially impacted, they should be there at the decision-making table. This is important because Indigenous peoples are the most excluded, marginalized sectors of society, and this has had a negative impact on their ability to determine the direction of their own societies. Right? So recognizing again the impacts of colonization, Indigenous peoples have been excluded. If we want to address things, Indigenous peoples need to be part of at the table when their rights are specifically and especially impacted. So EPIC is required when adopting and implementing legislation. It's required before any project that affects Indigenous peoples occurs. It's required before relocation. Increasingly, the question that I don't actually know if it's fully answered in international law is how are we defining relocation and how is that understanding going to be evolved? So if someone continues to use traditional territories for ceremony or continues to hunt on the lands, and if a development project is going to go forward that no longer allows Indigenous peoples to engage in those activities, is that sort of tantamount to relocation? I'm not exactly sure. I don't think that question has been directly answered yet, but I think there's potential for an evolution of our understanding of relocation. And EPIC is also required before the storage of hazardous materials. So I included a few of the comments by the former Special Rapporteur on the Rights of Indigenous Peoples, James Anaya, on consent. He also wrote extensively on free, prior, and informed consent. When I hear people, including, can't remember now if the news article I read this morning was from Globe and Mail or if it was from the National Post, it's like, that one headline, right? We don't know what consent is, so recognizing these rights is inserting uncertainty. When I hear lawyers saying this at conferences, when I hear this, I think what people are saying is we don't like what free, prior, and informed consent means. There are very small, minute areas that we need to sort out on how they apply in Canada directly. But we don't want to upset the cart because it's working just fine for us. What is uncertain is what happens to the people who've had the power and control to make these decisions if they're no longer the only ones making the decisions. What does that world look like? So I think any uncertainty might be, what does the world look like when Indigenous peoples are no longer having to pay the price for development, but actually get to be part of that process? But the law is very clear. I've got a 20-page report. I can give you 20 international human rights decisions. We know what this looks like. But yes, Canada may look different and we may not know exactly what that looks like, but it's not the law that's uncertain. Sorry, some of this may be a little reiterated. When we talk about consent and not just sort of consultation like the duty to consult in Canada, I think a couple of really important distinctions arise. It requires Canada and the Canadian governments to listen to the concerns of Indigenous peoples and attempt to address them, right? That's how you get people's consent, is you have an idea, you propose it, you listen to concerns that may arise, and you see about how you can address them. And it's not to downplay and say, oh, well, that's not a real concern, right? Well, they've raised it. It's a real concern to the people who are raising it. And I think it changes the way from this sort of weird one-way process of Canada as the decision maker under the Canadian Constitution. And so they have all the information, they run it past Indigenous peoples, maybe hear some issues, and then go back and make their decision, to actually working together to form a solution, right? So it really changes the role of who's making the decision and how, right? So it requires good faith negotiations with the intention of addressing Indigenous people's concerns. And while the Canadian constitutional decisions actually say this, I'm not sure we fully appreciate what that looks like yet. There's also lots of protection for treaties. So basically, one thing that I'll highlight is this idea that treaties are an international responsibility and have an international character. So basically what the UN Declaration, as well as the American Declaration of the Rights of Indigenous Peoples are recognizing, is that the Canadian law that in the 1930s said that treaties are sui generis and they're not international treaties or some other domestic agreement, wasn't well supported in law at the time. The judge has said this many times. No reference to any existing law that made that. He sort of made it up. But it also reminds us that these treaties, so treaties 1 through 11, are international, have an international character, so they are nation-to-nation agreements and are an international responsibility. So the UN is concerned about treaties and their implementation. I'm pretty sure I'm out of time. We need to reconsider the scope of Section 35. Maybe what I will, oh, I didn't tell you this. Sometimes I'm thinking, I might end up saying it, maybe don't do it. But what I want to just end with is looking at what Bill C-262 did and what were some of the criticisms. So the bill was really simple. Do people know what Bill C-262 is? Sorry, this was the bill that Romeo Saganash introduced and championed that made it through the House, made it through first and second reading in the Senate, made it through committee, and then was ultimately blocked by all sorts of procedural maneuvers by conservative senators. Failed to get it to third reading for the vote before the House rose, and so it did not pass. But I think it's important to recognize how many stages it went through. So this bill clarified that the UN Declaration applied in Canada. And it's important to say that it was a clarification because even without the legislation, the UN Declaration applies in Canada. What the first thing this bill just wanted to do was make sure that everyone, government, lawyers, judges, they all understood that it applied. So we no longer had to make that submission in court, for example. Right? It was like, okay, we're all starting off on the same page. It applies in Canada. The bill required government to take action to ensure all laws were consistent, so a review of laws. It required the government to develop a national action plan to implement the Declaration, right? Because the UN Declaration is an instrument to be pursued in a spirit of partnership and mutual respect, the bill requires the government to sit down with Indigenous peoples and other stakeholders potentially to develop a plan to implement the UN Declaration. And then it required some just annual reporting to Parliament, right? Making some sort of accountability measure. We're not just going to let this sort of legislation pass, but we're going to actually require annual reports. And then also clarified that the UN Declaration cannot diminish or extinguish any rights in the Constitution. So it can add to our existing understanding of Section 35, but the UN Declaration can in no way limit or reduce. So really simple, straightforward bill. Some resistance. Initially, ITK, no, I don't know what it stands for. One of the national Inuit organizations. Does someone know what ITK stands for? Inuit. I should have it in my notes somewhere. So ITK, it's one of the national Inuit organizations. They initially expressed some resistance, mostly because they said it didn't go far enough. In part because it was initially a private member's bill, it couldn't have any monetary implications, so it couldn't spend any government money. And one of the things that ITK has been pushing for is an Indigenous Human Rights Commission. So a place that Indigenous peoples could go to assert a violation of their rights. That was not just through the Canadian court system. And so this is coming back up. Untitled Chapter, the president of ITK, is back in the news saying, we're hoping that the new legislation will include this. And as well, I think a little bit of concern from ITK that the bill was drafted by Romeo Sanganash, a member of the Grand Council of the Treaties. And so a concern that I think was eventually alleviated, that the legislation was initially developed without the involvement of the Inuit, which is a fair enough concern, I think, but through conversations, by the end, we didn't hear ITK raising these issues. We did have a couple of conservative commentators expressing concerns that it's simplistic. I guess that's a criticism. We know that when you write simple, straightforward legislation, it then becomes a point of contention. It's not reflective of Canada's world-leading legal protections. I don't understand that one at all. Misconstrues Canada's existing and sophisticated Indigenous rights regime. I don't understand. It says that Section 35 can't be diminished, so I don't know how it's misconstruing anything. It adds in new uncertainties and risks hindering reconciliation. I have not yet figured out how it did any of those things, unless, again, we understand what I was talking about, some of the uncertainties. Dwight Newman, a prof at the University of Saskatchewan, and works at the conservative think tank, says that Bill C-262 doesn't take into account the complexities of constitutional, legal, and political relations, shifts a lot more powers to the courts. I'm not sure how it did that. It didn't change anything. If you're only clarifying that something applies in Canadian law, I don't know how you're empowering judges in any way or different way than they can already do. This one was one that I really got upset with right one day at a conference, that the government needs to move more slowly and cautiously. I don't think we can move slower, right? Like, it's 2020 now, right? Canada and the British have been around a long time. The other problem with this idea of moving slow and cautiously is it fails to appreciate the price Indigenous peoples are paying for the current status quo, right? So I sort of very forcefully said to Dwight, we are dying. Like, literally dying, waiting for Canada to take a different approach. Suicide, murder, missing Indigenous women and girls, the poisoning of lands, grassy narrows, and the failure to clean up a mercury contamination that we've known about and accepted for long periods of time. Our current approach in Canada is killing Indigenous peoples. If we say we have to move slower, all I hear is that we, a certain group, are perfectly happy the way things are moving. If you want to change that and not be paying the price, we need to sort of move slow, right? That the sort of fear of losing something. And I just think that that's far too high a price to pay. Maybe there are things that we don't know, but I'm not sure we know the implication of any piece of legislation when it's passed. We guess, we sort of say, this is what it should do. This is what we're hoping it'll do. But you never actually know until it's out there and someone takes, interpretation and it's applied in process. There's always uncertainty. And I just am pleading with people that we can't wait any longer. The cost is just too high for Indigenous peoples. And so I and a whole bunch of other people are working to push the Canadian government to ensure that new legislation comes through quickly so that we can start the process. We don't want to wait anymore. And so I think that's probably all that I put in. I didn't talk about my interpretation of the BC Act. I think I can say it really quickly. The BC legislation basically does all of this. And so I think it's a great first step. There's one small difference. I'm not sure I can remember off the top of my head. But it's really just a BC specific thing. I don't know if it makes reference to modern treaties or something, but I think it's great legislation. It's as far as I think any government is going to go at this stage. I think the real question is, what is the government going to do now to implement that legislation, and how are they going to interpret their responsibilities? So I will leave it at that.